all that lengthy, so if you're comfortable standing for a short time, we'd rather have you stand with us. So, and then when we get to Q&A, if you want to go back to the seat, that would be fun too. So if you want, everyone just kind of come up more to about where I'm standing. So everybody, we're still have a few minutes. We still have a few minutes, so as we prepare to get started, I just wanted to make sure everybody, I know most of you by now, I think almost all of you know Travis quite well. Some of you may or may not have met Jamal yet. Jamal's one of the members of our team from Zoom. You've met him in Zoom meetings, if you've been on the Zoom meetings. And then Margaret is also a member of our legal team. She's with the Koskoff firm. I think some of you have met her colleague and partner, Josh Koskoff, who's been on some of the Zoom meetings. So we, the four of us, collectively represent our four firms that are all part of the coalition that is representing you. But we are not the only members of each of our firms. And in most cases, we're not even the most important members of our firms, as you probably know from interacting with all of the other staff and people that are there to help you and work on your case. And many other people from both of our firms are here today. So, and I know you've corresponded with many of them through text, through Zoom, or seen them in the office. So, thanks for coming. So, I think we're just about good. Do we have in terms of just make sure
We've got about 7 minutes.
Yeah. Yeah, I mean, we could probably start if we have everybody assembled. But.
Excuse me, a lot of the people that need signing can't see.
Okay.
Signing.
That's a very good point.
Bring
So can we please?
Yeah.
Can we have everybody who needs signing to come up front right here so they can see, please? Is there anybody else? All right, so just to give you a preview for what's going to happen, we're going to give a brief statement and an announcement that involves the legal case that we're moving forward with. And then there are a few representatives of your client community that will also be giving brief statements. And then following that, we will take questions from the media. The lawyers will be answering questions. We don't expect that there would be questions directed at individual clients, but if that comes to pass, we can deal with that on a case-by-case basis. Following the conclusion of our statements and the Q&A portion, everybody is free to leave. The media is here, and some of them may be attempting to talk to individuals. No one is required to speak to the press.
We have a special exit for you over here.
If you want to exit out the back door, you can do that, and hopefully you won't be accosted. If you are, though, you can just politely decline. If you're somebody who does want to speak to the media and they have a request, then we will take that up and discuss that with you, and we can arrange something with them for that. But no one should feel any pressure to do anything or say anything that makes you feel uncomfortable or that you don't want to do. Okay.
Let me just make sure. Does Joe have everything he needs?
I'm ready. I'm good.
Okay.
Yep, I'm ready to go. Yep, I'm good.
Okay.
And we have, you're going that way. So.
Liz is saying yes. So we're just making arrangements when
Yeah.
Liz does come up.
Hold. Joe's full name. Joe Toledo.
Toledo. Yep.
Joe Toledo.
Yep. Correct.
Well, I just.
we're going to get started in a moment here, and just a request. We really appreciate the turnout today from the media. We have an interpreter here, Joe Toledo, and we would ask that he be in the frame while we're talking. That's really important for access for the deaf community and other people that will be viewing this. So if we could please remember to keep him in the shot while the attorneys and other clients are speaking, we'd really appreciate that. Thank you.
Thank you all for being here today. Many of you have met us in the past, but just for those of you who haven't, my name's Ben Gideon. I'm a lawyer at Gideon Asen, which is located across the river in Auburn, Maine. And I'm here today with Travis Brennan of Berman and Simmons, which is a law firm located right down the road in Lewiston, Maine. We're here with Jamal Al-Safar, who's from the National Trial Law Firm that's based out of Austin, Texas, and with Margaret Donovan, who's with the Koskoff firm that's located in Bridgeport, Connecticut. And the four law firms that we represent are the coalition of lawyers that represent 100 clients that were victims in the mass shooting that occurred in Lewiston, Maine in October of 2023. So what we intend to do today is to make a short statement, an announcement. Attorney Brennan and I will be making the statement and announcement. We will then present short statements from two of our clients representing our group of clients, and then we will open it up to your questions. So we are now just about 1 year from the day that an Army reservist whose job was to train soldiers in the use of firearms and grenades entered a local bowling alley and a bar in Lewiston, Maine, armed with an AR-10 assault rifle and a night vision scope, and opened fire on large groups of innocent men, women, and children who were there that evening. Many of the people standing with us here today were there that night at that bowling alley and that bar. Many of the people that are standing with us were injured when they were shot by that Army reservists. Many of the people that are standing with us watched as their friends and their family members were shot and killed in front of them at that bowling alley and that bar. And still other people that are standing with us were not there that night, but they waited for hours by the telephone or at different locations, only later to learn that someone that they loved more than anyone else in this world would not be coming home to them. They learned that their husband or wife or the father of their young children or their best friend or their significant other would never be coming home to them again. It is a day that nobody standing here will ever forget, and it is a day that will forever live in infamy in the state of Maine and in this country.
That day of October 25th, 2023 is a day where this great state joined a long list of other states where innocent people have been gunned down in mass shootings. Mass shootings are an epidemic in this country, and they have affected places that we normally think of as safe and secure. They've occurred in schools, on college campuses, They've occurred in churches and synagogues, parks, and now they've occurred in a bowling alley, and they've occurred in a local bar and grill. What these incidents show us is that these incidents can happen. They can happen anywhere, to anybody. No matter where you go, no matter how safe you feel, no one is immune from gun violence in this country. And unless people stand up and speak out, these tragedies will continue. Unless people stand up and speak out about the broken systems that lead to these incidents, nothing will change. Today, all of us stand here, our clients stand here, demanding that action be taken. They are standing up, they are speaking out, and they are taking action.
So we are announcing today that we have served a legal claim on the federal government for the failures of the federal government and the Army Reserve and the Army medical providers to have taken steps that would have prevented this mass shooting. We have filed on behalf of each of our individual 100 clients a detailed statement presenting that claim. Our detailed claim, presented on behalf of each of our clients, outlines the many red flags and warning signs that the Army had over a 7-month period leading up to the mass shooting that should have been acted on and were not. Our detailed claim outlines how the Army became aware that its service member was experiencing a precipitous and severe decline in his mental health. The Army promised his family and others that it would take steps to treat it and to manage it, and the Army broke that promise by returning Robert Card to the community without any diagnosis of what the root cause of his illness was or any clear plan to treat it. Our claims detail how the Army promised Robert Card's treating doctors, who said it would be unsafe for him to return to the community given his mental illness if he had access to weapons. The Army promised that it would take steps to make sure that he no longer had access to firearms, including the 6 assault weapons that he possessed. But once again, the Army broke that promise by allowing service member Card to continue to possess all of those firearms, including the Ruger AR-10 that he used to commit the mass shooting. Our claim details how the Army let Robert Card return to this community without informing local law enforcement of critical details, including his doctor's directive that he no longer have access to weapons, and the Army's own plans to revoke Robert Card's weapons while he was on an Army base so that he could no longer present a threat to other service members. And our claims detail how the Army downplayed and it minimized the threat that Robert Card posed to the community, even after they received what Army personnel have now testified under oath before the Maine Commission were what they believed to be credible threats that he was going to commit a mass shooting. Now, after all of that, the Army did its own investigation. And in their own investigation, the Army couldn't ignore the failures and the missteps that happened here. The Army acknowledged that it violated its own policies, including the policy that would have required them to explore what the root cause of Card's illness was and to determine whether that was service-related or not. They violated those policies, and they acknowledged that. But then the bottom line result from the Army was that they whitewashed that by stating that they had no responsibility for what happened here, stating that nothing they did or didn't do contributed to the result that happened here. So we are here to say, on behalf of the 100 people we represent and the people that were there that night at the bowling alley and that bar, that we do not accept that result. We do not accept that it was okay for the Army to ignore warning signs and symptoms for Mr. Card over a period of 7 months, to promise to address his mental health issues, and then to do nothing about it. We do not accept that it was appropriate to return Mr. Card to the community without understanding what the root cause of his illness was or having any reasonable plan to treat it, particularly because it was clearly getting worse. We do not accept that it was okay for the Army to omit critical information and not provide it to local law enforcement, including the information that his own doctors said it would be unsafe for him to be in this community with access to firearms. And we do not accept that it was okay for the Army to downplay and minimize what it has agreed were credible threats to commit a mass shooting. And so as a consequence of all of that, and the Army's failure to take responsibility for its own actions, when the notice period expires for the claims that we have just now served, we intend to pursue a lawsuit against the United States government, the Army Reserve, and Army medical providers by filing this case in federal court.
We are initiating this legal process because this community, this state, our clients deserve accountability. They deserve accountability for the broken promises that were made by the Army to address this and their failure to do that. They deserve accountability to ensure that something like this never happens again in this state. The legal process that we have initiated is based upon facts. Facts that were found in the Army's own internal investigation. Facts that are based upon the sworn testimony of members of CARD's own unit. Those facts reveal that there were 3 critical times in 2023, 3 critical times where the Army had an opportunity to intervene and failed to do so. The first critical time was in May 2023, when Robert Card's son reported that his father and his mental health was deteriorating, his behavior was erratic, and he had access to countless firearms. The Army learned of this, the Army promised to address it, and they broke that promise by failing to do so. Critical time number 2, July and August of 2023. Robert Card was hospitalized for 16 days at a psychiatric hospital. He was hospitalized because there were concerns that he had homicidal ideation. His own words were that he reported, "I'm afraid of what I might do. People are scared of me because they know I'm capable." He had developed a hit list, quote, hit list. Members of his own unit were so concerned about his behavior and the threat that he posed that one described Mr. Card as having a 1,000-mile stare. Another said that in interacting with Robert Card, the hair on the back of his neck stood up. And despite all those warning signs, and despite the recommendation from Robert Card's medical providers that he be separated from his firearms, the Army broke that promise and failed to do that. And what happened? Robert Card was permitted to walk right back into this community, into our state, and to have access to his firearms. What did the Army do? They acted to protect themselves by restricting his access to firearms on the military base. But they took no similar action to ensure that this community, this state, and our clients were protected. These are the facts. We continue into September, third critical time period here. Robert Card reports that he could, quote, take out 100 people. He reports that he might shoot up the Saco base. And finally, one of the members of his own unit says he's scared Robert Card is going to snap and commit a mass shooting. These are the warning signs that were there. These are the warning signs that the Army knew about. And what these 3 time periods demonstrate is that there were multiple warning signs, multiple opportunities for the Army to intervene, and yet they failed at every opportunity.
You know, what's most striking about this case is how little concern the Army showed for one of its own, for its own service member, Mr. Card. You know, the Army here, as you've seen when you read the facts, they knew more about Robert Card's deteriorating mental health than anyone else did, even his own family. The Army knew more about the risks that Sergeant Card posed to the community than anyone else. In looking at mass shootings in this country, a disproportionate number of them are caused by current and former members of the armed services. And there's probably reason for that. Number one, military personnel or soldiers, they're trained to use weapons of war to maximize the number of casualties they can commit with those weapons. But perhaps more significant, members of our armed services are subjected to lots of trauma and forces in the jobs that they have to do and the sacrifice that they have to make as a member of our armed forces. For example, in Robert Card's case, as someone whose job was to train cadets in the use of firearms and grenades, he was literally subject to thousands of blast events during grenade training. And so it comes as little surprise, perhaps, that members of our armed services can suffer from mental and from physical conditions that can lead to problems, when they can become a risk to themselves, leading to suicide, or risk to others, leading to shootings like what happened here. But let's take a look at what happened here. A year ago, this hadn't happened yet. Robert Card was still living amongst us. He was 40 years old. He had been in the Army Reserves for more than 20 years. He joined when he was just 19 years old. And for almost that entire 20-year period, he had an exemplary record. He had never received a single citation for any misconduct, and he regularly received good performance reviews from his command. After the shooting, the Army went and interviewed some of his colleagues, some of his fellow reservists. They described Card as a quiet, calm, kind, and generous person. So what happened here? How did Robert Card go from being a normal, stable, respected member of his reserve unit to somebody who was suffering from hallucinations, delusions, severe paranoia, homicidal ideations, having a hit list of people he wanted to kill, lashing out violently at others, lack of emotional and impulse control, feeling himself and confiding in his doctors that he didn't know what he might do? How did that happen? And more important than that, why didn't the Army care enough to find out the answer to that before October 25 of 2023? And perhaps even more important than that, How many other Robert Cards are out there right now that are current or former members of our armed services who are suffering from mental or physical illness and who have ready access to assault weapons?
The Army Inspector General's report concluded that Robert Card was, quote, singularly responsible for this tragedy. That conclusion overlooks the fact that all these warning signs were overlooked repeatedly. It overlooks the fact that there were multiple opportunities where the Army could have intervened and did not. It overlooks all the promises that the Army made to intervene and the broken promises that followed. The Army bureaucracy failed Robert Card. The Army bureaucracy failed this state and community, and it failed our clients. The problem is that the Army bureaucracy persists in this state of denial. They conclude they didn't do anything wrong. The problem is that they can't fix a system that they don't believe is broken. And that's why we're moving forward here today, is because our clients are taking this important next step because they want accountability, they want answers, and they want fair and just compensation for what happened to them. With that, we're going to now hear, before we hear from a couple of our clients, I think it's really important as we approach the one-year anniversary to, again, we have all our clients here today. I'd like to take a moment of silence and read the names of the lives that were lost, and obviously there are countless others who are here who were either injured or witnessed these terrible events. I'm going to read the names. Ronald Morin, Peyton Brewer Ross, Joseph Walker, Arthur Strout, Max Hathaway, Keith McNair, Joshua Seal, Brian McFarland, Stephen Boisella, William Brackett, Thomas Conrad, Michael Delorier, Jason Walker, Tricia Aslin, William Young, Aaron Young, Robert Violet, Lucille Violet. We ask for a moment of silence to recognize these 18 lives that were lost and all the other survivors whose lives have forever been affected by this tragedy. Please join me in a moment of silence. Thank you. I'd now like to introduce Cynthia Young to make a brief statement.
Hello, I'm Cynthia Young. Last year on October 25th, my life, as well as so many of the others here today, was changed forever. My husband Bill and my son Aaron were taken from me in what seems like an instant. I kissed and hugged them both, and I told them I loved them, I pulled my son back for a second hug, not knowing it would be the last time I ever saw them. It's so difficult for us to relive those moments. There's pain, trauma, and regrets that will never go away. And I know most of the people here with me feel the same. As terrible as this shooting was, it's even more tragic that there were many opportunities to prevent this, and that they were not taken. There were multiple people and agencies who saw, the warning signs leading up to October 25th, and they did not take the proper actions to stop Robert Card or to get him the help that he needed. There needs to be accountability for those actions not taken that led up to the 18 souls being lost, and also the loss of feeling safe and secure for the survivors of this tragic event. Moving forward, I hope that we will initiate changes within these agencies that will stop this from ever happening again, and to prevent anyone else from ever having to experience the depth of pain and grief that we have. Thank you.
Next, we're going to have a brief statement from Elizabeth Seal.
Hello all, my name is Liz Seal. I'm the wife of Josh Seal, one of the 18 victims of the shooting in Lewiston. Josh was only 36 when he passed away, but he accomplished a tremendous amount in his short life. He worked as the Director of Interpreting Services for Pine Tree Society. He worked as a certified deaf interpreter. He worked with deaf individuals ranging in the educational realm as well as medical, and his priority was communication access. He was deaf himself. He had 4 deaf children, and he knew the importance of those social interactions and that opportunity for engagement. He set up the Pine Tree Camp Dirigo experience for that need. He was only 36, but like I said, he accomplished so much, and he had so much more to do. It didn't matter how busy he was, he always made time to devote to his family. He cherished us first and foremost and was so devoted. He always took time to spend with his 4 children, one-on-one and as a family. I am so grateful that my children have special memories of their father. However, he's not here anymore, and I'm left with 4 children who miss their father tremendously. Our oldest is 13. He's graduating from middle school soon and moving on to high school. He doesn't have his dad around to chat about anything, about navigating the teenage years, or strategizing about his competitive events and sports, how to engage and improve on his sports. We have a 10-year-old daughter. She was a daddy's girl. He was wrapped around her little finger, and he would have done anything for her. She's going to be graduating from elementary school, moving on to middle school, without her dad there to protect her, to chat with her, to answer all of her inquisitive questions, to play, in her creative mind with her. I have a 7-year-old. He just started a new school. Dad's not around to help him manage his emotions, regulate his feelings, read with him, go outside and play to get rid of some of his boundless energy, burn off some of that steam. He will not be here for that. My youngest is 4. He's going to graduate from preschool and go on to kindergarten. Dad's not here to watch his t-ball games, to see him get that first school bus ride, or to hear his stories, his mischievous stories. He's not going to be here for any of that. For me, I don't have my husband any longer, my life partner, the one I navigated everything with. I don't have my partner here to support me. He was my anchor in the storm, and he helped level my even keel. And we were able to talk about and navigate anything. It's impossible to know whether this tragedy could have been prevented, but obviously there are several steps that could have been taken to prevent this tragedy. If those steps would have been taken, we may still have our 18 loved ones with us today. I don't want this to happen to any other family. We need to keep the people who acted in a neglectful way accountable, because they may have been responsible for the loss of our 18 loved ones. And for those of us who are victims and survivors, the emotional and physical trauma will stay with us forever. Once justice is served, I feel maybe we can start that process of healing. But in the meantime, we're going to stay Lewiston strong.
With that, we'll turn it over to any questions that people might have.
We got a small statement back from the DoD and the Army today, basically saying they don't want to comment on pending litigation. But I just want to get your thoughts on if you expect to hear them comment on this, or do you expect to see them wait for this 6 months to just time itself out?
We don't expect to hear back. Sometimes we do, sometimes we don't. The main thing that we're focused on is we're focused on moving forward, and we're prepared to do that now. We obviously have to wait 6 months, but as Ben pointed out, on 6 months and 1 day, we're ready to go forward.
Do you anticipate your action will eventually name individuals and not merely institutions?
The way you bring a claim when it's a federal tort claims case, which is what this would be, is always in the name of the United States. Only. No individuals or even subdivisions are named.
Carrie, you have a question?
Do you anticipate any legal action to local Maine law enforcement, or is it just directed towards the U.S. Army?
The case that we're here to talk about that we've noticed is only against the U.S. Army, and we do not anticipate at this point any case against local law enforcement. As you may have seen in our claims against the Army, local law enforcement was not provided with all of the critical information that the Army had about the risks presented by Robert Card, including, most significant, that Card's treating doctors had directed that his firearms be removed. That information was omitted from information provided to local law enforcement. And there are other things as well that are in our statement about that.
Susan?
What about Four Winds, which is a contractor for the Army? What about, could you possibly add that hospital later?
That option is absolutely still on the table, and that ties into one of the actions that we recently took last week with Cynthia Young being appointed as special administrator of Robert Card's estate. That permits us to get Robert Card's complete medical record from Four Winds and from Keller, and we think that's going to be critical in terms of filling in important pieces of the puzzle in terms of not only what his providers were thinking on a day-to-day basis, but their communications with people in the Army chain of command and their recommendations that we don't think were followed up on. Thank you.
Yeah, as a veteran, I'm not going to ask either of you have served, but obviously there are federal limitations per code, United States Code and Army regulation, on what the Army Reserve can actually do and how much power they actually have. So what are your thoughts on that, and B, do you think there need to be changes to that law, to how that's handled, how the Army Reserve is handled?
Thank you. Thank you for your service, and that is a good question. So we understand that the Army, in its report, took the position that it was limited based on some of the federal regulations law you're alluding to, but we don't agree that there's any limitation on following through on promises. I think the law permits the Army to follow through on the promises it makes. We don't think there's any federal law that prohibits them from exercising common sense. We think there were a number of junctures here where there was a complete lack of common sense. And there's no law that allows the Army to violate its own policies. And in this case, they did violate a number of their own policies.
Well, to be fair, Robert Card is what we in the active duty service would call a weekend warrior. 1 weekend a month, 2 weeks a year, he would do that. The rest of the time, he is legally, by United States code, a civilian, and the Army has no authority over him. What are your thoughts on that?
So the Army's own investigation concluded they had jurisdiction over him when he went to West Point. They had jurisdiction when people's hair was standing up on the back of their neck. They had jurisdiction when he was talking about having a hit list. And they had jurisdiction throughout his entire psychiatric hospitalization. In fact, they extended his order so that he remained within their jurisdiction. What is puzzling and very troubling is that they didn't then continue to his order so that they remained or kept jurisdiction over him when he left Four Winds Hospital. And the Army's own internal investigation has demonstrated that they should have, not could have, they should have done a line of duty evaluation during the time that he was at Four Winds and coming out. And we believe, had that been done, had the SAFE Act report been made, that would have resulted in a different outcome here. Thank you for your question. Other questions? Yes.
How are the two firms from outside of Maine helping in this case? What specifics can you give on why you want it to happen, obviously?
Sure. So, I mean, I think it's, as we've pointed out, before this tragedy last year, we had never had a mass shooting here in Maine. And once this happened, Ben and I quickly spoke and realized that this was going to be an incredibly important endeavor, and we wanted to assemble the best possible coalition to serve these incredible clients. And that naturally led to reaching out to Jamal and his firm, National Trial Law, and to Margaret and Josh, the Koskoff firm in Connecticut, because they have a wealth of experience handling and working on those types of cases. So we have been integrated from the beginning. We've been working together. There's a lot of work to do, and everyone is involved in that. Other questions? Yes, Emily.
How much of your case you expect will deal with his exposure to like blasts, and if you have any thoughts at this time on the policy changes the DoD announced after some analysis of his brain, for their members' exposure to blasts?
It's a great question. So in terms of the blast exposure, what's known at this point is that we know that after the incident, Robert Card's brain was sent to the BU CTE laboratory led by Dr. McKee, who's known to be the national expert in post-mortem analysis of brain pathology. In fact, she's done a large extent of the NFL concussion cases, and so they're very knowledgeable about that. And their conclusion was that Robert Card's brain, while not technically diagnosable as CTE, showed changes on pathology consistent with brain injury to the white matter of his brain that would have correlated to some of the behaviors that were seen in his precipitous change in behavior over the last 7 months of his life. Now, I don't think anybody can say at this stage that there's clear evidence that his conduct was caused by blast exposure, but what we know for a fact is that it could have been, and the Army didn't evaluate or investigate that. And by the way, it didn't evaluate or investigate any other cause of his change in condition either. And why that's so important here is because if you have a physical injury that's manifesting in a change of behavior, that's a progressive and worsening process. And if you send somebody home, there'd be no expectation that they would get any better from that. In fact, all of the evidence was that he was getting worse over time and would continue to get worse. And the minimal records we do have from Four Winds, the Four Winds doctors actually concluded that it was unlikely that Robert Card was going to get better or improve after he left, which is one reason why they were so insistent that if he's going to go home, you've got to make sure he no longer has access to weapons.
Just to add on that, Emily, so over the past year, we've collected a lot of information through different FOIA requests, through the Army's investigations, just in the same way that all of you have. But one of the advantages of litigation is it provides additional tools that we have to make requests to obtain information that the federal government and the Army in particular doesn't have to voluntarily release to us. So we would expect to request and better understand what research the military's done on the connection between these exposure to concussive devices and its effect on mental health. But that's not something that the government has voluntarily shared with us at this point.
I did just want, sorry, just to add on, the policy changes, I know it was after the fact, but do they affect your case at all, or do they address any of the changes that, if you were to find out it played a bigger part in this case, you'd warn? Like, have they done enough there with promising like initial screenings and more education around class exposure?
So I think it's still early, and there's just more information we're going to need. I think we have time maybe for one or two more questions.
So Maine's two senators, Collins and King, have both drafted legislation to basically require the military or allow the military, I should say, to use like red flag laws, yellow flag laws here in Maine when they are aware of information. What are your thoughts on that, and how might that affect?
I know you were at the commission hearing, so you heard Kelvin Moat testify. He's the first sergeant of the Card's unit. He testified that his intention in drafting that letter that ultimately went to Saginaw County was that that be used to exercise the yellow flag law. That's what he said under oath when he testified. However, nobody ever communicated that to the Saginaw County Sheriff's Department. And far from requesting that they execute yellow flag, as he apparently had intended be done, they minimized and downplayed the risk and essentially told the Saginaw County, don't bother him, you can go home now. So while I think that's an important change, I don't think it affects what happened here, because I think that the statement that they needed to directly execute yellow flag is somewhat of a smokescreen, because as Sheriff Schofield has already testified, had he been asked specifically to execute the yellow flag, had he been told that the Army doctors had directed the removal of Card's weapons, there's no reason to suggest that that couldn't have occurred here.
Phil.
What's the timetable and your expectation that the Army will turn over those personnel and medical records that they've already been ordered to turn over by the Saginaw County Court? Is it related in any way to the 6-month timetable that affects this litigation, and is there any indication that the Army will quickly or not so quickly cooperate?
With respect to the authorized requests for Robert Card's personnel records, we expect the Army to timely and promptly turn those over to us. That's not related to giving notice of an intent to bring this proceeding, so we expect full cooperation from them. All right, thank you very much. We appreciate everyone coming today.
Yeah, guys, there's a